Hi friends, in this video, we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of Constitution, that too in relation to matters involving entitlement of unmarried women to seek abortion of pregnancy, in term of 20 to 24 weeks, arising out of consensual relationship, and exclusion of unmarried women, who conceive out of live-in relationship from medical termination of pregnancy rules is unconstitutional. To know more about the abortion of pregnancy arising out of consensual relationship case, please watch this video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled, X versus the Principal Secretary, Health and Family Welfare Department, Government of NCT of Delhi and another, pronounced on the 29th of September 2022, the Supreme Court has held that unmarried women are also entitled to seek abortion of pregnancy, in the term of 20 to 24 weeks, arising out of a consensual relationship, and exclusion of unmarried women, who conceive out of live-in relationship, from the medical termination of pregnancy rules is unconstitutional. The facts of the case would be that appellant who was unmarried became pregnant as a result of consensual relationship. The appellant wished to terminate her pregnancy as her partner refused to marry her at the last stage. So, the appellant sought permission to terminate her pregnancy in terms of Section 3(2)(b) of the Medical Termination of Pregnancy Act 1971 and Rule 3(b)(c) of the Medical Termination of Pregnancy Rules 2003. The appellant instituted a criminal miscellaneous application for grant of interim relief to terminate her pregnancy during the pendency of the writ petition. The High Court held that Section 3(2)(b) of the Medical Termination of Pregnancy Act 1971 was inapplicable to the facts of the present case, since the appellant, being an unmarried woman, whose pregnancy arose out of a consensual relationship, was not covered by any of the subclauses of Rule 3(b) of the Medical Termination of Pregnancy Rules. The order of the High Court gave rise to the present appeal. The Supreme Court has held that the object of Section 3(2)(b), read with Rule 3(b), is to provide for abortions between 20 and 24 weeks, rendered unwanted due to a change in the material circumstances of women. In view of the object, there is no rationale for excluding unmarried or single women, who face a change in their material circumstances, from the ambit of Rule 3(b). A narrow interpretation of Rule 3(b), limited only to married women, would render the provision discriminatory towards unmarried women and violative of Article 14 of the Constitution. Article 14 requires the state to refrain from denying to any person equality before the law or equal protection of laws. Prohibiting unmarried or single pregnant women, whose pregnancies are between 20 and 24 weeks, from accessing abortion while allowing married women to access them during the same period would fall foul of the spirit guiding Article 14. The law should not decide the beneficiaries of a statute based on narrow patriarchal principles about what constitutes permissible sex, which create invidious classifications and excludes groups based on their personal circumstances. The rights of reproductive autonomy, dignity, and privacy under Article 21 give an unmarried woman the right of choice on whether or not to bear a child, on a similar footing of a married woman. The reproductive rights of women must be harmonized in light of the principles laid down under the Constitution, as well as the principles of international law codified in the various international conventions ratified by India. This court's interpretation of the Act and the rules furthers India's obligations under international law. However, the state must act proactively, in order to ensure that women in India are able to actualize their right to reproductive health and healthcare, in line with the obligations assumed by the country under international law. The Act recognizes the reproductive autonomy of every pregnant woman, to choose medical intervention to terminate her pregnancy. Implicitly, this right also extends to a right of the pregnant woman, to access healthcare facilities to attain the highest standard of sexual and reproductive health. It is meaningless to speak of the latter in the absence of the former. Reproductive health implies that women should have access to safe, effective, and affordable methods of family planning, and enabling them to undergo safe pregnancy, if they so choose. The state must ensure that information regarding reproduction and safe sexual practices is disseminated to all parts of the population. Further, it must see to it that all segments of society are able to access contraceptives, to avoid unintended pregnancies, and plan their families. Medical facilities and registered medical practitioners must be present in each district, and must be affordable to all. The government must ensure that registered medical practitioners treat all patients equally and sensitively. treatment must not be denied on the basis of one's caste or due to other social or economic factors. It is only when these recommendations become a reality that we can say that the right to bodily autonomy and the right to dignity are capable of being realized. Further, nothing in this judgment must be construed as diluting the provisions of the Preconception and Prenatal Diagnostic Techniques, Prohibition of Sex Selection, Act 1994.